Good afternoon. Today we're going to talk about divorce. Unfortunate topic, unfortunate state of affairs. For my own part, I believe in marriage, I believe in love. So if you're married, when you get married and while you're married, maintain your marriage. Go to church, talk, resolve the issues, keep the marriage alive and strong and well. But in the event that you need to get a divorce, let's talk about what you do. Alright, so divorce today in Jamaica is relatively painless. It's a paper procedure. There was a time when you needed to go to court to give what we call viva voce evidence. Not required anymore. You simply give counsel the information, counsel prepares the affidavits and the petition, and you sign off on them, and they're filed and served on the other side. The bailiff has to serve it, and the bailiff will sign a document saying he swearing that he served the papers on the respondent, and you have to give the bailiff a photograph. Bailiff will identify the person by virtue of the photograph. Once that is done, then counsel will file what's called notice to dispense with the hearing. So there's no necessity for hearing. All that is required, whatever would have been said in the hearing, is required now in the affidavits and the petition itself, sworn to. The affidavits are sworn to by the JP, who swears to the signature of the bailiff. Once that is done, you have to wait 6 months before you can apply for the decree absolute. The decree absolute is what dissolves a marriage. The nisi is an order to allow you to apply for the decree absolute. Get the decree nisi first, then the decree absolute, and 6 months later you apply for the decree absolute. When you get that, you are no longer married. Easy as cheese. And then you can remarry. If you remarry, well, you can't remarry. There's no second marriage. If you're married to someone, you can't marry to someone else. You can be charged for bigamy, which is the attempt to participate in a marriage ceremony while you are married. So don't do that. You have to wait until you get the decree absolute first before getting married. There are a few issues. The main issue that will come up are, the main issues that may come up are: one, the maintenance, custody, and access to any relevant children. It's preferable that the parties, respondent and petitioner, sit down with their attorneys and sort out the terms upon which, or who is going to contribute what to the needs and the necessities of the child, with whom the child is going to live, which school the child is going to go, whether the child is hale and hearty or suffers from any disability, and if so, who will take care of that, how much is the petitioner going to contribute, if any, depending on who the petitioner is, because anybody, wife or husband, can petition the court for the divorce. So it is recommended that both parties sit down with their attorneys and hammer out the terms, so you can go to the court and say, these are the terms. It's going to cost you if you can't do that, because if you have to go to court to argue for the two sides, and the lawyer's going to argue as to what the court should order, because the court is going to order a state of affairs to look after the child. Counsel is going to charge you, and if you're senior competent counsel is going to charge you anything from up to $250,000 an hour to argue. So it's recommended that you sit down at a table with or without the lawyers, preferably with the lawyers, because the lawyers will be able to guide you as to what makes sense and what the court needs. So after you arrive at that, you file that with the court. If you can't arrive at a settlement of who looks after the child, then the petitioner would put in an affidavit what the child requires, the amount amount of money the child requires, schooling, etc., and leave it to the court to decide. If the respondent makes no answer and doesn't challenge what is written in the affidavit by the petitioner, then the court will be minded to accept that which is said on the face of it, provided it is satisfied that the respondent was served with the papers, input in this particular wise, the arrangements for the child. Another issue that can come up is where you don't know where the respondent reside. Now, if you don't know that, you might want to apply to the court for what's called substituted service. But that assumes that you have a general idea, a general geographical idea. If all you know is that the respondent lives in the United States of America, you have a problem. Because you can apply to do substitute service, which means use some other method to serve her besides the bailiff. But if all you know is that the respondent resides in the United States, you're going to have to publish, if the court grants it, you're going to have to publish it. Because what you're asking for is for the court to order that you serve the respondent by way of substitute service, by way of newspaper, media, television, print. But if you don't know which state the respondent is in, what are you going to do? Every state? You might have a problem. You're going to need to do a little investigation to try and tie down a geographical area so that you can say to the court, this is where the respondent lives somewhere in this area, and I'm asking that you allow me to serve her by way of substitute service, by way of print media or electronic media. Another way that I have found that works is if you know for a fact that the respondent has counsel wherever she is, and counsel may be prepared to accept service on her behalf, and if that's his behalf, if that's the case, then your problem is solved. Of course, you might know where the respondent lives, but that the respondent lives outside of the jurisdiction, in which case you can serve the respondent wherever the respondent is, provided you can satisfy the court that you did so serve. Your spouse may be deceased, in which wise, or you're assuming the spouse is deceased because you haven't seen the spouse for some 7 odd years. You have to apply to the court to dissolve your marriage on the basis that the spouse is deceased, and there are certain grounds you have to file, certain circumstances you have to satisfy the court. No one has seen him for how long, he hasn't been in the country, all the evidence you can present to the court to satisfy the court. Person is dead, and on that basis still dissolve the marriage. You can also apply to the court to nullify a marriage. Now, when you nullify the marriage, you're saying the marriage never existed at all, as against dissolving it. That application has several grounds. Well, before we get into the grounds for nullity, let me just say there are no grounds needed for a divorce in Jamaica. All you need is to prove you're living separate for 12 years, 12 months. And separation means cohabitation. Cohabitation means love and affection. If it's 12 months since you loved and showed affection to your wife or husband, you can apply for the divorce, petition the court for the divorce. If your marriage is younger than 2 years, you have to prove other grounds. The court will very seldom allow you to dissolve your marriage. If your marriage is younger than 2 years, you'll have to prove that you sought counseling from an approved marriage counselor. Now, in terms of nullity, if you purport to marry someone younger than 16, you can dissolve that marriage. If you're married to someone using a person who is not a qualified marriage officer, you can dissolve your marriage. If there is any kind of fraud, you can not nullify the marriage. So once you satisfy all those things and the 6 months pass, you can apply for the absolute, and then you're divorced. But as I started out by saying, if you can solve your issues and your problems, because you must have loved the person in the first place to have gotten married. If you still love the person, I recommend try and save the marriage rather than getting a divorce. Alright? Next time.